Good afternoon again, everybody. Thank you so much for joining us. I'm Tammy Welty. I'm the Director of Training and Communications here at Bradford and Barthel. Today's webinar is on Don't Stop Peddling. They may be gaining on you. It's going to be presented by Don Barthel. He's going to talk about some case law today. We also have Louis Laris joining us. As you can see, he's an equity partner and the director of our appellate division. He's going to be assisting with questions today. Let's meet Louis and Don. Louis, you want to take it away?
Sure. Thanks, Tammy. Good afternoon, everybody. My name is Louis Laris. I've probably had the pleasure of working with many of you in various capacities. I head up the appellate division for the firm, as Tammy mentioned. I'm also an equity partner with the firm. I've been with BMB for over 22 years, I think it is. 23 years, actually. Time flies. And happy to be here. And happy to answer any questions you have during the presentation or even offline. My email address is there. If you've got any questions, even if it's a case I'm not handling, more than happy to help out and give any insight or input that I can, drawing on that experience with years of handling recons, removals, petitions for writ of review, and even arguing before the various district courts of appeal and the Supreme Court. So with that, I will turn it over to the main man, Don Barthel.
Main man, I think that was a fat joke, wasn't it? Like, thin person, you. All right. Well, we're going to start off with some of you who were a little early heard a couple bad jokes. I'm going to finish off with a really bad joke. There's a robber at nighttime going through a house in the dark, and he hears a voice. Jesus is watching. He thinks this must be his imagination, so he continues on until again he hears, Jesus is watching. He turns his flashlight on and sees a parrot. Did you say that? Yes, I did. Well, what's your name? Moses. What kind of people name a parrot Moses? The same kind of people that can name a Doberman Jesus. But okay, Louis, come on, fake a laughter. Ed McMahon. All right, our next webinar is coming up on August 14th. Be there. It'll be fascinating, and you'll also be able to get your continuing education or MCLE. Thankfully, the COVID questions are far and few between at this point. But if you have any, and I just saw one yesterday, please go to our COVID at bradfordbarthel.com email, and we can get you an answer. Usually, an answer within 12 to 24 hours. In fact, almost guaranteed. The rating department, which I'll make reference to, it's actually not the rating department, it's the AMA Guides evaluation department, where we make sure that the report has been properly applied the AMA Guides. And I commend that to you. If you're, for example, ever preparing for a doctor deposition, this provides a wonderful outline for attacking doctors' reports. Tammy mentioned the continuing education webinars online and the blog articles, so I shall continue on. And let's get to Cisneros. 1 and 1 is 3. This is a very frustrating case. LA Unified seemed to actually have done most everything right, and yet they were told they did it wrong. They were told they they failed to meet their burden of proof. Let's find out. First, we had speaking of COVID, the employer requirement that everybody be vaccinated. Now, the applicant's personal doctor, not a PTP, QME, or an AME, but Dr. A, said, well, a million years ago, she had a reaction to a hep vaccine, and she hasn't received any more, so we don't know if that continues to be a problem. And COVID is different from hep C, so for hep, so we wouldn't expect it to actually make a bit of difference, but it could cause a rash or fatigue. Now, is this substantial evidence? I really don't think so, but nevertheless, wiser minds than me have decided otherwise. So as a result of this, the applicant said, I need an accommodation, and a reasonable accommodation, which is always scary language because we're dealing potentially with the Fair Employment Housing Act and the Americans with Disabilities Act. She said, what I need to go online and do everything via the phone line, the Zooms, et cetera, et cetera. And the thing we were all doing for a couple of years, it seemed like. She completed the employer's accommodation form that they had provided. And in response, the employer said, no, this is an essential job function being there. So really, unfortunately, the only choices are resigning or retirement. So in the interim, she went to a QME who said, or subsequently, she went to a QME who said that the vast majority of her psychological problems were due to personnel actions, and this personnel action in particular. As I said earlier, at trial, it was determined that the essential job function was being at work physically. And however, the judge noted some of the accommodations were actually provided to other employees. And they made a big deal about this. Well, if you can make an accommodation to everybody else, why can't you make an accommodation to this person? They failed to differentiate one accommodation from another. And obviously, they're all going to potentially be different. I think the defense may have fallen short on their work here. Let me give you an example. Under FEHA or ADA, you have to provide a reasonable accommodation. But if you, for example, you have a blind employee who needs a reader, mom and pop kettles, three person shop, probably that wouldn't be reasonable but General Motors can more than afford it. So reasonable depends on this, is case specific. So I'm not sure that this, again, I think the defense may have screwed this one up.
Hey, Don.
Yeah.
I'm sorry to interrupt you. Would you mind raising your voice just a little bit? We're having a little bit of trouble hearing you.
Really? Nobody ever has a problem listening to my voice. Usually it's just the other problem, that opposite. Sure, I will speak up.
Thank you.
The employee, it was indicated that the employee was not given an accommodation because her doctor failed to indicate the duration, how long this accommodation would need to be in effect, how long she should be working from home. The employer contacted the employee via an email and said, okay, here's what we need to do. We need to determine, one, if you really have a disability from your perspective, two, you're relying on a serious medical condition, or three, it's a religious belief that's causing your claim for a need for an essential change in or provision of reasonable accommodation. And also the certification you provide from your doctor that said you needed an accommodation, it's missing information. It's missing the duration of the accommodation. And so we really need that. And we can't take any further action until you've provided the necessary information. The WCJ said, okay, you've done everything you could possibly do, employer. This matter is barred by the good faith personnel action or defense. On Recon, however, as I suggested earlier, the WCAB said wrong. It was seen that they've basically made it mission impossible for a defendant to succeed in this type of scenario. It's not impossible, but it's very difficult. They said, now, if an employee proves industrial site claim, then the employer must demonstrate that it was substantially, quote unquote, caused by a personnel action. I'll get to that in a second. It must be lawful, it must be non-discriminatory, and it must be in good faith. Well, we're going to get to good faith. That's the big one. But the discriminatory was not explored, but given the fact that there was a description of other employees getting accommodations, there may have been an argument of discrimination here as well. But the focus was on good faith. And then the judge under Rolda, and you may remember this case from way back, but this provides us a good umbrella of what needs to be proven. The judge has to determine whether the case involved actual events of employment. Back in the day, a million years ago, when I started 30 years ago, in a site case, you could file a successful site case by saying, I thought my boss, or I think my boss is Satan. I mean, literally. And therefore it drove me crazy. Well, that's probably not an actual event of employment. You're probably going to have a tough putt proving that your boss is Satan. After that, you have to prove that actual events were the predominant cause. Well, back in the day, again, you had to prove that a scintilla of the of work caused the site problem. But now we know it's predominant cause, definite improvement from the old law. And if so, whether any of the actual events were personnel actions that were, again, what we just described, lawful, non-discriminatory, or in good faith, and if so, whether that's a substantial cause of the psych injury. Now, what's good in good faith? Good faith is so it can't be outrageous conduct. It has to be honest. It has to be sincere. There has to be no intent to mislead or be unlawful. I can't see anything here that could so be described in terms of the employer's behavior. But they also mention in the Romero case, it must not have problems with unclarity. In other words, the rules must be clear. Management must follow proper procedures. The duration of the accommodation, they said, remember the employer said, well, your doctor didn't say what the duration of accommodation is, so therefore we're not going to negotiate and determine reasonable accommodations, etc. The duration of the accommodation, they said, well, duh, it's as long as you're requiring the vaccine. Well, those are what you call facts not in evidence. I don't think that's a fact at all. They're just assuming it, and talk about ties all going to the runner and the board bending over backwards for the applicant's sake. They said the employer didn't appropriately communicate the need for this information. Well, they sent an email, so I'm not quite certain what else they should have done. The employee proposed reasonable accommodations, and the employer failed to engage in its own interactive policy. Well, that interactive policy is required by California law, FEHA, the federal ADA, and the only thing I can see that they might have done wrong is to again put up that we're not going to talk any further until you get that medical report. Obviously, they could have continued the negotiations, and if the medical report came down and changed anything, they could consider that at a later point. So remember, all right. The rules regarding the duration of accommodation, the consideration of remote work, and the evidence as to why the accommodations were granted to some are unclear and show management personnel may not have followed the procedures. May. Look at that. Okay, this is the heart of the ruling. They may not have followed the procedures. They may not. Again, I think this is a very conservative WCAB bending over backwards to help the applicant. But what is the important impact of Cisneros? You may have all your T's crossed and your I's dotted where you go into this in this type of scenario. Don't rely on, for example, the fact that you've asked for certain information and the applicant has failed to provide it, or including securing a medical report, because remember, evidence is going to be interpreted against you if at all possible. We need written documents put into evidence, policies, handbooks, procedures, any and all documents that the applicant might have seen that would guide their behavior, as well as any guidelines that the employer provides, or that the employer commits themselves to following. Personnel testimony, managers, supervisors may very well be needed and needs to be considered. And we need to be able to prove that the rules, the employer's rules, were reasonably, openly, consistently, and uniformly applied. Upshot of this case, it's going to be very difficult for the employer to succeed in one of these scenarios. The WCAB has made that very clear. But let's get into a more fun case, the extended premises rule. The THARP matter came down just this last January. We have the employer, Arcata, we'll just call him A, and that's where the applicant worked. Now, nearby, there's another piece of property not attached to Arcata called Figus, and the applicant had actually gone over there for lunch, uncompensated lunch break, and managed to get himself injured there. Now there was a conflict. Quick, get a priest. He's speaking in tongues. There was a conflict in the arguments. The employee claimed that Figus was controlled by his employer, that his employer owned both properties, and that occasionally stored equipment at this other piece of property. The employer said, no, we're separate corporate entities, and I never store any. Well, the WCAB or the WCJ said, no, the employer does own both property. I'm sorry, does not own both properties. They are separate corporate entities, but he does occasionally store equipment on the other piece of property where the applicant was injured. Happily, hey man, holy moly, there was a take nothing. They said, well, remember the going and coming rule bars injuries suffered during a commute to a fixed place of employment at fixed hours. But this is not that situation. Injuries going and coming to work upon premises owned or controlled by the employer are AOE, are work related. I just said that the earlier one was not the situation. Yes, it's exactly the situation. I said a mere piece of equipment being stored on somebody else's property does not make an extension of the premises line rule appropriate. Quote, even if the employer occasionally stored a piece of equipment on the other employer's piece of property or loaned a piece of equipment to that other employer, this is not sufficient nexus. They're not sufficiently connected to call F the premises of A. Now, the panel agreed that the occasional quote unquote presence of equipment does not establish A has controlled, and that's an important word, controlled the property. What does occasional mean? Well, I looked it up in the dictionary. It means infrequently or irregularly. In other words, it doesn't really help us terribly much. But I think the focus should be somewhere other than the word occasional. I think the focus should be on how the employer interacted with the employee in terms of his relationship with that other piece of property. The employer apparently had never instructed implicitly or expressly for the applicant to go to the FIGUS piece of property. It appears that the applicant did so solely on his own terms. It was never instructed to do so expressly or implicitly. If there had been, for example, a piece of property or equipment owned by his employer on the other piece of property and he'd been instructed, was expected to go get that, I think we'd have a completely different situation. So this is one you're going to love. Police officers, go ahead. It's a physical job. Their employer expects them to be in good physical condition. They exercise, they get injured. It's work related, right? Maybe not. In this particular case, there was an off-duty officer who was doing some kickboxing. And of course, he was injured. And of course, he said, well, I needed to keep in shape for work. So there you go. This is the rule as they came down this just recently. They said, no. In most compensable cases, again, the employee is training for a fitness test or performing perform a specific activity or to be in good general condition for the job. But interestingly, there was no departmental rule that officers must be in good physical shape. In other words, eat all the jelly donuts you want, guys and gals. Feel free to get flabby, like yours truly. Apparently, I am in a position to become a police officer for the city of Los Angeles. They said there's no departmental order of this. And however, and I think this is more important, the department manual said there are certain situations, there are certain that where we will consider that your injury while training is work related, but it has to occur only at specified locations. That is, you're training at specified locations. And this place where the officer was doing the kickboxing was not one of those. What does the law say on this? Well, it says specifically that if the injury doesn't arise, it's not covered, it's not work related if the injury arises out of a voluntary, completely voluntary, off-duty recreational, social, or athletic activity. If it's not voluntary, if it's not part of the employee's express or implied work-related duties, then it's not going to be work-related. However, if it's the opposite, if it's involuntary, implicitly or explicitly, expressly or impliedly, a reasonable accommodation. If the employee subjectively believes that the activity is work-related and it's objectively reasonable, not that it really is required, but if they subjectively believe it, and a reasonable person would have believed that, it's called a reasonable expectancy, it will be found to be work-related. For example, let's say Bradford and Barthel has a baseball team, and we compete with folks in the industry, and we're in the big final game, and our first baseman is injured. Tom Bradford goes up to a young associate and says, "I understand you have a good mitt. We'd really love to have us join us and take first base, and I'd really appreciate that. Now, you don't have to do it, but I'd really appreciate it." Well, let's see here. Tom has said it's not required. He expressly said it was not required, and yet, would a young associate, when asked by the guy at the top of the letterhead to engage in an activity that's important to that Tom Bradford, wouldn't it be likely that they subjectively believe that they really probably shouldn't do? They really should do that for their own good, for their own career, and wouldn't that be objectively reasonable? That's the kind of thing we're talking about. Now, one added footnote to this: employers are to post in a conspicuous place notices advising employees that certain activities are, and by name, certain activities or types of activities are not to be considered work-related. The statute also says that the failure to do so will not constitute the intent to waive that preclusion, but baloney. I don't believe that at all. I don't believe that there's going to be a lot of employers who successfully defend these cases unless they have a posting or at least something in writing that explains to the employee that they don't have to be doing that activity. Note here, in this particular case, there was a department manual for everybody to read in this that would apply to this particular case. All right, how crazy is crazy enough? In other words, how long do you have to have worked in workers' comp? I've got 31 years down. I think I'm definitely nutty enough, and I have 5 children, so I'm
Hey, Don.
Yeah.
I'm sorry to interrupt. We've got 2 questions that pertain to the last topic, actually, with regard to arguably non-work related activities.
Yeah.
So this one's from Carol. If the employee is on a business trip at a ski resort and voluntarily goes skiing with other members, could that arguably be related?
Well, I don't think that would be what we'd be dealing with here. I think what we'd be doing is at a reasonable part, they're on a business trip. Is it a reasonable behavior for somebody who's on a business trip? And well, is it or is it not? Is it reasonable expectancy that somebody sent to the Swiss Alps would, in their spare time go skiing? I could see arguments going both ways. I really can. What are your thoughts?
Yeah, I think I was thinking of a case that was handled by another attorney actually in our office here in Fresno, involving a guy who actually worked for China Peak, one of the local ski resorts. He was filming while skiing and injured, while actually off duty. And there was a lot of disputes. And I think there's actually a statute that covers that specific scenario. Yep. But in a situation like this, where it's a business trip, and there's no, I think it's going to boil down to the expectancy issue or the question. If there is no expectation, there's no, hey, you need to come to build camaraderie or anything like that, then I think it's going to be found to be non-industrial, non-work related.
I would agree, but I think also you need to consider exactly what the nature of the work is. If it's an accounting CPA convention, be one thing. If it's, on the other hand, if it's a ski equipment a fair selling various equipment or advertising various equipment, some big get together by everybody in bigwigs in the industry, owners and managerial employees of ski equipment companies, yeah, I'm probably going to go the other way. It's going to be very fact specific.
Yeah, yeah. I was thinking of a ski travel agency that sends employees to various places, and if they send them to a ski resort to review that ski resort to see if they want to market it to their customers, yeah, then that may be facts sufficient to bring it within the workers' compensation system.
Well, isn't that why we become a travel agent in the first place?
Exactly. Yeah. One other question along the same lines from Isabel Rivera. What if a police officer is on his way to work driving the city-owned motorcycle when he is involved in a car accident? Is that work related if he is not performing a duty for the employer?
I think that's black and white, and the reason is he's driving or riding the employer's provided transportation.
Right.
If he were in his personal car or on his personal motorcycle, much more likely to be found non-industrial, but almost guaranteed, if not guaranteed, to be found industrial, given that he's using the company car, so to speak.
Yeah, when transportation is contemplated as part of the contract of employment, essentially, which is why I always carried a file in my car.
Right.
Became a partner.
Now, if
I got involved in an accident.
If he decides he's going to be Evel Knievel and goes off track and out of the instead of going from A to B, he goes all the way to C and up a mountain and does some jumping. That may be different, but
yeah, substantial
otherwise
deviation.
he's going to have a pretty good argument on his hands.
Right.
Okay, so how crazy is crazy? Well, you don't have to be crazy, apparently, but it helps to work here with this, as they say. We had a denied cite case, and it was settled for de minimis amount. She was represented, but then she said, you know what? I want more money, AKA, I wasn't in my right mind when I signed the CNR. I was not taking the right medications. Now I'm on Haldol. I am paranoid and schizophrenic. Here's my doctor's report that says exactly that. And because of my paranoia and schizophrenic, because I was schizophrenic, I was afraid my co-employees would come to where I lived and get me that way. So the question was, well, is she competent? Was she competent at the time she signed the CNR and the order approving issued, or is she stuck with that contract and the approval of same? And the answer is she competent? Absolutely no cigar. What does competent mean? Well, it does not mean crazy. It does not mean some of the really tougher parts of the global assessment function that you'll find in your permanent disability rating schedule. It means simply the inability to properly manage or care for oneself or property without assistance. Now, that's a sliding scale. Somebody just needs help with a checkbook versus somebody who needs shouldn't be holding $5. That this is going to be a case by case basis. But remember once again that the judge is going to bend over backwards to find that there was not competence at the time. If you face that situation and you think that perhaps you want to make sure that this case does not revive and have a new life, you might have a QME or PTP comment on the person's competency to understand and enter into a contract at the time at the time the CNR is drafted and signed, and then include that in the CNR. No, as implied, the statute of limitation is told if they're ever found to be incompetent or incapable, and so you could end up reopening this case years down the road. All the more reason that you consider getting a PTP or QME to comment on this, whether the commenting saying yes, indeed, I find this person to be competent. The QME found non-industrial, a good one for our side. The applicant testified, I had to retire. I got too much pain and it was all work related. And it was held, well, here's your money, said the judge, because that's what judges do. The WCAB said, not so fast, counselor. He said, you only get TD upon retirement if you prove something for change by a preponderance that you intended to continue to work once you got better. How do you prove that? There's only one place that you're probably going to be able to get that information or evidence, and that's at the deposition, when the applicant's not really aware of what's going on when you're asking that line of questioning of prior, when were you planning on retiring? Had you planned retirement years earlier? What was your plan? Where are you going to live, etc.? Sort of to mix it up and finally get the, yes, I was planning on retiring by January 1, 2025, and here I have been injured, and it didn't change a thing. Oops, says applicant's counsel. Another good one for us. The judge at applicant counsel's request issued an order to produce for deposition the claims examiner, because he wanted to harass the claims examiner and the person most knowledgeable regarding the training of adjusters. And why did you want to do that? Pretty much to harass them too. And I sound like I'm being sarcastic, but I mean it sincerely. What great cards up your sleeve if you're an applicant's attorney to start ordering the production for deposition, or trying to produce adjusters and supervisorial personnel at the insurance industry or at the TPA. The WCAB said in this particular case, nope, you can't do it. Why? The judge ordered it to be done. If this information seems to be, the sought after information seems to be reasonably related to the issues at hand. Why? They said, well, you did it procedurally wrong. You're supposed to use a deposition notice or subpoena under 5710. We're supposed to follow, at least consider, the CCP, the Code of Civil Procedure. Remember the 5710, Labor Code Section 5710 of the deposition statute doesn't mandate the use of the CCP, doesn't say we have to follow CCP, but that we can and probably should use it as suggested. So why does that matter? Well, under the CCP, there's more due process available to the parties, including a meet and confer requirement. That is, before a judge orders anything, the parties have to get together to try to hammer out into a compromise or agreement, and if not, then go to the judge. So it's really a procedural and constitutional issue. By the way, did somebody mention AMEs? I'm going to get on my high horse, on my soapbox, and start screaming and yelling about AMEs. If you've heard me say this before, you can fall asleep for the next 4 minutes. If not, hold on to your hats. A long while ago, I did an article, a blog article called The AMA Trap, Why Agreed Medical Examiners Make Me Disagreeable. This was a long time ago, and I've actually even grown to believe this more and more. Here's what I hear. I want to rely on a doctor I know, and I know Dr. AME Schmo. Or it's best to use a doctor with a track record, and Dr. Schmo's been around forever. Or who knows who's going to be on that panel, PQ&E panel. Well, the WCAB, will say, we choose an AME because of their expertise and neutrality. That's not the case, and we know that's not the case. The truth of the matter is, we want somebody to split the baby and make the tough decisions for us that we can't resolve on our own, or we don't dare, and that's often the case, allow the judge to decide. But we go from the judge to an AME, from the fire pen into the fire oftentimes. What are the downsides? Well, I'm going to go over them, a lot of them. Our AMA analysis rating department that I referred to earlier has literally analyzed about 20,000 medical legal reports to determine whether the AMA gates have been properly applied. Speaking of which, we have a little black book of all the doctors we've examined. And so if you need the name, if you have a name of a doctor, you need to know whether they're good, bad, or indifferent in terms of properly applying the AMA guides, let me know, and I'll both get that information from the AMA analysis department, as well as our local office. We've got offices across the state, so and just get in contact with the managing attorney of the local office. But based on those thousands of analyses, we find that 81% of the time, the doctors don't apply the AMA guides correctly. And 79% of the time, I know you're going to be just shocked by that, he said sarcastically, they overstate the whole person impairment. Who actually does the best job of applying the AMA guides? Believe it or not, it's the PTP, because he or she generally does not have a dog in the fight. They don't have a personal interest in the matter. Second place goes to QME, and who is the most expensive and takes the longest to get in for a deposition, etc. Who does the least best? Those are the AMEs. They are the most problematic doctors when it comes to properly applying the AMA guides. And remember, if they're misapplying the guides, there's an 8 out of 10 chance that they're overstating the amount of impairment. So, and let's give some examples. What percentage should be 0% if you properly apply the guides? 1/3 of the back cases properly applying the guides should be 0. 2/3 of the carpal tunnel cases should be 0. Hernias, unless there was a malpractice in the hurt surgery, fast approaching 100% should be 0. Do your numbers comport with that? Not what we see. The doctors are not comporting with that, despite the fact that the AMA experts, including editors and reviewers, provide these kind of numbers. So you want to, but let's say you want to rebut the AME, PTP, or QME. You hate the PTP and or QME report. You say, well, hey, things can't get worse. Let's go to an AME. Well, whenever you say things can't worse, invariably means they get worse. And let's say you have gone to an AME, and the AME provides a very unhappy result, and you want to get rid of the AME. You need to take the doctor's deposition in hopes that the judge will rely on the PTP or the QME. So you need to take the Dr. AME's deposition to make them look stupid. That sounds pejorative, but it's the absolute truth. When I want to render a report to be not substantial evidence, I need to prove that the doctor doesn't know what the doctor is talking about, which in this day and age is a lot easier to do. We're no longer dealing with the 1997 PDRS. We're dealing with the AMA guides. If we know the AMA guides better than the doctor does, and some of us do, and the AMA, our rating department does, it's not even a fair fight. We have the advantage. And there's also, back in the day, they used to say, when you're deposing a doctor, you don't argue medicine. They went to medical school. You argue the facts because you went to law school. Well, as a matter of fact, nowadays that's different. At Bradford and Barthel, we spared no expense in providing wonderful research tools to research medical issues and studies and information about medical conditions. If you haven't gotten it, I recommend you do. It's called Google. I never take a doctor deposition without Googling the background. More about that later. Anyway, so you try to cross-X and make the AME look stupid. The judge is going to say, nah, all the case law says, or virtually all the case law says, you chose them for his or her expertise. You chose them for his or her neutrality. Unless you hit a hole in one, you're not going to overturn the AME's findings. I mean, after all, I said, after all, there we go. The AME is your expert. They're your guy. They're your gal. They're your witness. And now you're trying to prove that your witness isn't substantial evidence. It just doesn't ring true. That's not true of the PTP or the QME. They're not your guy. They're not your gal. They're not your chosen expert. They're not your chosen witness. Now, back in the day, a million years ago, nearly 20 years ago, when I started studying and teaching the AMA guides, I was an innocent because we were already within the first half a year of application of the AMA guides back in 2005. We were seeing that the doctors were misapplying the guides. And I thought, well, they need to be taught better. They need education. Education is the answer to everything, right? Train them better and we'll get reports that make more sense. Otherwise, garbage in, garbage out. Answer is, Barthel, you're wrong. I actually gave a speech that ended with that harangue in Santa Rosa about midway through 2005. I said, we need to teach the doctors better. Well, when I left the building, and was out in the parking lot, I was met by not one, but two individuals who identified themselves as AMEs. And they say, no, we don't need training. We understand the guys. I said, well, that's great. And we could actually apply the guys. I said, well, that's really great. But then they said, and this is a really big but, they said, we can't and won't ever properly apply the guys. Huh? You can, and you would, but you can't and you won't. What does that mean? They said, well, let's quiz you, Barthel. Let's go back to those facts and figures I talked about earlier. We agreed, they and I, that the back 1/3 of the time, the carpal tunnel 2/3 of the time, and the hernia nearly all the time should be zeros of properly applying the guides. And then they said, well, here's a $64 question. Quote, if we properly apply the guides and give zero to 1/3 of backs, 2/3 of carpal tunnel, 2/3 of the carpal tunnel cases, and nearly all the hernia cases, what happens to our AME business, and more importantly, how in the world are we going to be able to afford our vacation home in Hawaii? They were indicating they've got a vested interest in making sure they can properly apply the guides. So when somebody tells me I am going to lie and cheat and steal, I gotta assume I'm going to lie. They're going to lie, cheat, and steal. I'm not judging them. I'd probably be doing the same thing if I were them. But they do have that vested interest. Just know that going in. All right, enough about that. Let's talk about subpoenas. We talked about notices to produce. Now we'll talk about a subpoena. The employee wanted a subpoena to produce the person most knowledgeable, the PAK, the person who can really talk about how earnings and earning capacity or the information about their earnings so that we can determine, or they can determine their earnings and earning capacity and their TD and PD rate. I've only seen this happen once. I expect to see it happen much, much more, because what a great negotiated tool. You've got a person most knowledgeable in New York or Texas or Maine, and to force them to be subpoenaed to a deposition is a major cost for the defense, and may help lead to the settlement that the applicant wants. They also wanted a deposition of the UR doctor. And the WCAB said yes and no. You're good to go with the person most knowledgeable, not so good with the utilization review. And after all, earning capacity is relevant, and therefore the testimony of the PMK is highly relevant. But there's absolutely no legal basis to depose the doctor, UR doctor. There's no penalties. There's no, you can't request to depose them. They're sheltered. And we made that decision a long time ago when we started to employ UR and IMR. So can't do that. But PMK, person most knowledgeable, expect to see that a lot more. Zelnik, how are we doing on time? Well, we got about 10 minutes. We'll get some of it. This is an interesting little case. It's an oddity and well worth knowing. The defense did not timely deny a site case on the basis of a good faith personnel action. They didn't do it within the 90 days. And the WC said, no worries, man. Again, it was an injury to the site, allegedly, and the denial came greater than 90 days. The WCJ said, well, it's untimely. It's greater than 90 days, so it's presumed compensable, right? 5402B bars the employer from asserting the good faith defense found in 3208.3 because you were untimely. The WCAB said, no, 5402 doesn't do that. They said, and they didn't really provide a good explanation. They said, this is just one of those exceptions to the 90-day rule. And we got case law dating back to at least 2019 confirming that. Although the psychiatric injury is presumed compensable under 5402, it is not precluded from asserting and presenting evidence of a good faith personnel action, regardless of when the evidence was obtained. Should have been obtained within 90 days, and you can use any evidence that couldn't and shouldn't couldn't have a reasonably been obtained within the 90 days. That's the general rule. That's not the rule with regards to the good faith personnel action. I don't really know why, but it's an arrow to keep in our back pocket, to mix a metaphor. This could have gone badly for the employer. We've got labor code, we've got a statute, both of which, they are mirrors of each other. or they exactly replicate one another. Evidence upon that is not pleaded on the answer, which needs to be issued within at least a couple of weeks, shall be allowed only upon the terms and conditions imposed by the judge. So you're definitely up to the judge's whims, and you're going to have to talk the judge into agreeing to allow that evidence in. And this is any evidence with regards to the answer. A lot of folks, whenever I give a presentation on answers, I find that probably 3/4 of the audience does not use answers, and yet they say, well, for example, after a couple of weeks, we have no idea what information we're going to provide, or what we're going to, how we're going to argue this. And the response to that is, this is merely a pleading. An answer is merely a pleading. It can be amended anytime, all the way up to trial time. So issue that answer, do it in a timely fashion, so you don't have the evidence precluded from being entered into or being used at the hearing because the judge doesn't like you. Yeah, Lewis.
Yeah, I was going to say, I've argued something along these lines in the past, and I think it is maybe quasi-jurisdictional, which is why subject matter jurisdiction, which is something you can't waive, right? So if there's an exception, a statutory exception to an injury being considered AOE, COE from a legal perspective, then the board by statute doesn't have jurisdiction over that. So you can't waive that defense if it's if it's for whatever reason not timely raised. You could probably raise that even up at the time of trial,
right?
Because it is subject matter jurisdiction, and that is kind of sacrosanct, legally speaking, not just at the WCAB, but even in civil matters. If there is no subject matter jurisdiction, and the board is an entity of statutory construction, and it has to abide by what the law says in terms of the board's jurisdiction, what it can and cannot decide. The clearest example of that is, excuse me, sorry. The clearest example of that, I think, is with UR, and when a UR decision is made timely, the board has no jurisdiction to adjudicate that dispute. And I think the same can be said for this type of defense as well.
Interesting. I will underscore this is why you go to Lewis for written recon questions on appeals of any sort. Not only has he done billions and billions, and I think appeared at just about every court of appeals and filed more recons than anybody I know, and that's literally true. But I'm going to offer up his help if you ever have a case where you're considering it, whether we're handling it or not handling it. You might want to run by him, see whether that's a fact pattern that sounds like it's going to work, whether it's something that would probably be ill-advised to take to an appeal, et cetera, et cetera. Lewis, you're welcome.
Thanks, Don.
All right, TD. Okay, I love this case, and I think you will too, just because of the name of the case. You got a furniture mover, and his job, everybody knows, you're going to be subject to drug testing if the employer wants it on a random basis or for cause. And he's injured, but his job now for modified duty is washing trucks and doing a little office work. The employer says, okay, we're going to drug test you. And the employee says, I'm not going to show up, and does not no-show. Gee, I wonder why. I don't think it was because of his argument that he had a constitutional right not to be drug tested. Just thinking. And then, of course, he's terminated for failure to appear. The employer proves that modified duties were available and that all modified duty employees are subject to testing. The employee argues, well, it wasn't good cause. I was not doing safety-specific work. And the question was, well, then is or is not applicant entitled to TD? Was it okay or was it not okay to terminate him? And the answer was, oh, heck no, he gets nothing. It was not irrational for an applicant to be tested or for an employer to test workers with safety-specific activities in their regular work, even if they're not performing that regular work right now, as long as it's expected or reasonably expected that they'll go back to that safety-specific activity once they're cleared medically. The termination was for good cause, and the TD properly stopped after termination. So congratulations, employer. You cut off TD, and you can subject this person to a rehire. Life's good. But more importantly, what's the name of the case? Lopez versus Meathead Movers. I love that. That's great. I'm glad the law firm is at Meathead and Movers. Okay. Providing a proposed rating string. Another reason you might want to consider talking to an expert about the report before you go in for the fight. Now, remember, I don't have any technological problems. There we go. 5502 says, you cancel this thing at the MSC, you file your pretrial conference statements, and you enclose your proposed PD rating. Now, this has been required for billions and billions of years, but lots of times people don't do it, and I don't know why. It certainly was needed in this Thompson case, really needed, and I'll show you why. This was the date of injury was prior to 1997, the bad old schedule for those of you who remember it. That may be the reason that these folks did, in this case, did not provide the proposed rating. It was just so much more difficult. If you've been doing workers' comp since the 2005 PTRS, you can't imagine, I mean this sincerely, how bad and difficult the 1997 and prior schedules were to play with. So they even stiffed that the 97 schedule was appropriate. The employee said, okay, at trial, the PDRS is rebutted, I want 100%. The problem was, what is the problem here? Remember, there was no proposed rating. No one told the judge what the proposed strict rating was. So the judge, but nevertheless, the judge says it's rebutted. Here's your 100%. Huh? How do you do that? There's a big logic problem here. How could you say A has been rebutted by B if you don't know what A is? If you don't know, how can you say that a proposed rating or this regular rating has been rebutted by a different rating that says it's 100% if you don't know what that initial rating was? You can't. It's impossible. And happily, the WCAB recognized that problem, said go back to trial level and do this thing right the way. Now, how bad is the situation? This case has been going on for almost 27 years, and the PD hasn't been resolved yet. Too bad they didn't do it the right way. Ledezma. How much? In other words, the WCAB will nail you for misusing procedures. Now, this is a really outrageous case with outrageous facts, but the WCAB has issued a decision on this issue en banc very recently, and I think they're sending a message that we boys and girls must really behave, or they're going to be looking askance at our behavior, and we need to do it the right way. And let me explain this. First, the crime. There's a petition for a removal. Petition for removal was filed to dispute a case being set for trial, and that's what you're supposed to file. A petition for basically what a petition for removal and petitions for reconsideration. If you're not happy about a case being moved to trial, you file a petition or removal nevertheless. However, applicants counsel and their hearing rep filed recons. That's not cool because that's not what this is for. They also waited to the last day to file the recons, and they never even appeared for trial. So they made it impossible to proceed. Actually, the judge probably should have just proceeded and said, the heck with you, but judges are always happy to find a time to cancel a case or push it over. It was found that they filed these petitions, quote, solely to delay the trial proceedings, and they should have asked for a continuance, and they should have showed up for trial. The potential punishment, well, there was a notice of intent to sanction applicant counsel and the hearing rep, $20,000 a piece for filing recons with the intent to disrupt, to delay proceedings. And there were more than one or two, plus reasonable expenses, plus attorney fees, plus costs. But the only thing they weren't threatened with was jail time. And who knows, maybe next time if the judge really gets ticked off. So the en banc decision that came down in May said, Oh, no. We won't do 20,000 apiece. We'll do 2,500 apiece. Still adding it up. 2,500 times 12 separate cases plus costs plus attorney's fees, all for being procedurally naughty. I think this was done because the fact pattern was so outrageous, and two, they just see a lot of that or think they see a lot of that. And this is a shot across everybody's collective bow in the industry to stop screwing up with recons and writs and use the right one at the right time. And they also very unimpressed with the defendant's apparent lack of concern or regret. In this type of situation, when the WCAB is looking to sanction me, yes, sir, no, sir, I'm very sorry, sir, it's probably always the best answer. Apparently, they hadn't gotten that advice from their mom and their daddy. They said, the WCAB said, here's our problem with this. You file frivolous recons, it's going to cost the WCAB in time and money. It's going to cause delays in other decisions issuing, and Lord knows we have problems with recons being granted and time for consideration later on. We'll talk about that in a second, the second Court of Appeal. It delays the determination of benefits in other cases, in the cases that bar and other cases. They don't like the time and resources of opposing counsel being wasted, the time and resources of witnesses who show up unnecessarily being wasted, the court reporters being wasted, the trial judges wasted. It hurts everybody, they said, and so we're not going to put up with it. Beware, we must, we knew this, but it's just been underscored here, accurately employ and label petitions as petitions for removal or petitions for reconsideration. And of course, if for any reason you can't get down to the WCAB for a trial, or heck, for any conference, etc., you immediately form the WCAB. You call them, not while you're driving, of course, but you find a way to get in contact with them. And if you want a case not to be set for trial, you file a petition for removal, not a petition for recon. So are they really that different? Isn't that a cute picture of me?
Don.
Hey,
Yes.
Don, I'm sorry. We are out of time.
Oh, are we? Oh, darn.
We are. I know.
Well, we got the same for a general idea. I just want to make one point really clearly. If you're not sure whether it's a petition for recon, removal, I know this guy, and I strongly recommend you get a hold of him. He'd be happy to answer whether or not we're handling the case. And look at how cute he is with no gray hair. I wonder what that's like.
Oh, goodness.
Thank you, everybody. The rest of the PowerPoint is available. It should be self-explanatory. And if it's not, please give me a call or email me or text me.
Yes, and I will be sending out certificates this afternoon, and I'll send a link to the PowerPoint as well in case you couldn't find it in the resources section. Our next webinar is August 14th with John Kamen on lien statute of limitations. You can register for that now on our website. And thank you all so very much for joining us today. We appreciate you, and we hope to see you next month. Take care, everybody.
Stay cool. Bye-bye.